Secret and half-secret trusts don't meet the formalities set out in Section 9 of the Wills Act 1837. So the question arises, why do the courts enforce these types of trusts? And I think this comes down to two things. Firstly, equity has an interest in seeing justice and fairness being done. And secondly, the courts are very interested in not allowing fraud to be perpetrated. So that's a little bit of background on secret and half-secret trusts, but what exactly are they? Well, let's get started with this lecture and find out.
The principles that underpin secret and half-secret trusts are relatively simple and revolve in the first instance around a testator, so someone who is creating a will to decide what happens to their property after they die, and for whatever reason the testator wants to pass on part of their property to a person who cannot be named. And the reason why they cannot be named is normally in the case law based around men who are creating a will, but they have a mistress and an illegitimate child, and they want to give some of their property to this sort of side family that they've got going on without letting their actual family know about it. So how do they actually go about doing this? Well, essentially the testator can pass the property through the will to an intermediary, and then this intermediary acts as a secret trustee, and the secret trustee holds the property for the benefit of the person who cannot be named. So essentially using a middleman between the testator and the person who cannot be named. So what's the difference between a secret trust and a half-secret trust? Well, fully secret trusts, as they're properly called, are not mentioned at all in the will, whereas a half-secret trust will be mentioned in the will, but the details of the terms of the trust are not going to be gone into. So there'll be an awareness within the will that there is a sort of secret trust going on, but none of the details will actually be in there. So how do we actually establish a secret trust? We'll start with the secret trust, although the requirements are essentially the same for half-secret trusts as well. But for secret trust, we've got the case of Ottaway and Norman that establishes three things that we need to look for as part of a secret trust. An intention to benefit the person who cannot be named, communication of that intention from the testator to the secret trustee, and then acceptance by the secret trustee of that trust obligation. So let's go through each of these 3 points in turn. Firstly, we'll start with the intention, and very simply the intention has to be to impose a trust obligation rather than a mere moral obligation. That comes from McCormick and Grogan. And essentially what we're talking about with a moral obligation is if I said I give £10,000 to Dave because he will know what the right thing to do with it is. Saying what the right thing to do is more of a moral obligation, whereas if I said I give £10,000 to Dave for the purposes set out in a letter to him on the 20th of December 2018, then it's going to be fairly obvious to Dave that this is the establishment of the reference to a secret trust, which I maybe mentioned in him to a letter on that date. Secondly, we have the requirement of communication. And this can be written or oral communication, but it has to include not only the intention to establish the secret trust, but also any relevant terms of that secret trust as well. And the relevant terms are going to be things like, well, who are the beneficiaries and what is the property that is going to be established? And that importance of certainty of subject matter, i.e. what is the property, is really important. In the case of Colin Cooper, we had a trust of £5,000, and then the testator tried to add to that afterwards, but they didn't properly communicate that they were adding to the trust fund with the secret trustee. So when they tried to make it more than £5,000, because that hadn't been communicated to the secret trustee, it was only the original £5,000 that remained part of the secret trust. So all of the terms do have to be communicated, and also in terms of the timing of that communication, it has to take place prior to the death of the testator, and that was established in Moss and Cooper in the old case of 1861. Finally, we have acceptance, and that can be express or implied. One of the classic cases in secret trusts is Walgrave and Tebbs. Here we had Tebbs being given £12,000 as part of a will, It was later found through various forms of written and oral evidence that there was an intention to create a secret trust, but Tebbs had never been informed about this and was not aware of it, and so because there hadn't been any communication, it was obviously impossible for Tebbs to accept the secret trust as well, and so that failed, and in that particular case Tebbs was able to hold on to the £12,000. So those are the three requirements, and as I said, for half-secret trusts it's basically the same thing. The only thing to watch out for with half-secret trusts is that the timing of the communication is a little bit different. So whereas with secret trusts the communication had to occur before the death of the testator, with half-secret trusts, because the half-secret trust is referred to within the will, the communication must occur before or at the time that the will is executed. And that comes from Lord Sumner in Blackwell and Blackwell. Now, before we move on and discuss some of the issues around secret and half-secret trusts, one of the other ways that this sort of secret trust can come into being is also through intestacy. Intestacy is basically where you don't create a will in the first place. And when that happens, there are certain rules about what happens to a person's property. Now, a person may decide not to create a will, knowing that their property will pass, for example, to their only son. And they may want their only son to then pass the property on to a person who they don't want to name. And so even though there isn't a trust in that situation, there isn't a will that's been established, a secret trust can potentially arise out of the intestacy if there has been that intention, communication and acceptance with the person who will get the money based on the intestacy rules. And the case for that is Selleck and Harris from 1708. So what happens if the secret trust fails? Well, there's basically two possibilities here. The money can either simply go to the beneficiary, which is what happened in Walgrave and Tebbs, or there can be a resulting trust so that the money reverts back to the testator's estate. And which remedy is actually applied in that situation is basically dependent on the knowledge of the secret trustee. So if the secret trustee had absolutely no knowledge whatsoever of the proposed trust, then that money will just go to them and they will be the rightful beneficiary of the property under the will. And that's what we saw in Walgrave and Tebbs. On the other hand, if the beneficiary did have knowledge that there was some type of trust, but it fails, for example, because it had not been accepted, then in that case, because we know that there is some sort of trust that has failed, then it will be a resulting trust that goes back to the testator's estate. So it's essentially based on the knowledge of the proposed secret trustee that there was going to be a secret trust or a half-secret trust. Another example of failure of the trust would be where, for example, the secret trustee dies before the testator dies, and in that particular situation there would be a resulting trust going back to the estate. Although some effect could be given to a half-secret trust, although that's going to be a little bit difficult because you don't really know what the intention of the original testator is in that situation. So moving on, the evidence can be problematic in this area as well. There's something called the parole evidence rule, and this prioritises written evidence over oral evidence. And you can imagine in the area of wills, where you have a clear written document that is a legal document as well, that is normally going to take precedent over any sort of oral evidence of a trust. And so that can be really difficult. Now, it's not a hard and fast rule, and sometimes the courts will look beyond it, but you can see that it creates a really difficult hurdle. Another hurdle that can be quite difficult to jump over is the standard of proof in these types of cases. And as per Lord Westbury in McCormick and Grogan, the requirement is the clearest and most indisputable evidence. And the reason for that high burden of proof is because essentially you're alleging fraud in this situation. You're saying that a beneficiary from a will is not the rightful owner of the property and should actually be a secret trustee. So because the claimant is alleging fraud on the part of the defendant, that's why we have this high burden of proof. Finally, the other thing that we need to talk about just very briefly is joint ownership. Now that chart there looks a little bit difficult to understand, but hopefully it's fairly simple. It's essentially very similar to the chart we had at the start, but instead of having a single intermediary, we have two. So we have A and B who are joint owners of a particular piece of property under a secret trust. But the problem in this area is that A knows about and has presumably accepted the secret trust, but B, who is still a joint owner of the property, doesn't know about the secret trust. And so the problem is what happens in this particular situation with respect to the intended beneficiary, which is C. And the question basically comes down to, when did A accept the position of being a secret trustee? If they accepted before the will is made, then both A and B are bound by the secret trust. However, if A accepts after the will is made, then it's only A who is bound by it, and B would be a rightful beneficiary under the will.
If you have the option to do secret and half-secret trusts as an option in either a coursework or an exam, then I think that this is somewhat of a double-edged sword. On the one hand, this is a relatively simple area, and it means that it's quite self-contained in terms of what you actually need to do and revise. On the other hand, this is quite a limited area, and so your ability to actually show a great degree of knowledge across the whole of equity and trust is somewhat limited, and so you might find that you're going to have to do a lot more to get some of the higher marks around like a 2-1 and a first. Nevertheless, if you're answering this as part of a problem question, remember that you will need to go through the different requirements, so intention, communication and acceptance, and also consider the relevant issues that come up in relation to the problem question and secret and half-secret trusts, such as intestacy, for example. If this comes up as part of an essay question, then you may want to consider the role of secret and half-secret trusts within this area of the law. So is it fair that these exist? Should the courts allow them, or should we just stick to the formalities set out in the Wills Act 1837? Hope that you enjoyed this video. If you did, make sure to leave a like and subscribe for more videos in the future. I'll be back with more videos in the future soon, but for now, bye!